So welcome to our second panel on abuse of red notices and the Interpol system. We are going to have Ariel Cohn will set the stage, then we're going to have presentations, we'll have Q&A, and stay seated because we will have runners bring around the microphones for you to ask questions, and we've left plenty of time for discussion since you're such a knowledgeable and interested audience. Thank you.
Thank you very much, Louise. I want to thank Louise for inviting me and to put a plug for Louise's new book, Dark Commerce, sorry. It's an excellent book, and I just started reading it. It's highly recommended. And of course, Louise is a national and international treasure, as recognized by the United Nations. The panel here is top-of-the-line talent. In the sequence I have it here is Ismail Shakhtakhtinsky, originally from Azerbaijan. Bruce Mizamore, that I've known for Bruce 20-plus years.
Probably.
And Melissa Hooper. You have the bios and the gentleman from Fair Trials that I don't have on my bio list for some reason. I don't know when they added you, but definitely.
Only from Fair Trial.
I don't have it. Definitely very, very relevant expertise. The question I'm asking myself is, what are the best mechanisms to ensure that authoritarian regimes that are members of the Interpol will not abuse the system to chase after their opponents? In my practice, in my experience, we had a case of Mikhail Khodorkovsky, the Russian opponent of the Putin regime and a former owner of the founder of the Yukos Oil Company that was harassed and chased around the world. I know Bill Browder, also harassed and chased. And these are the most prominent people and people with resources to fight the abuse of the red notices back. But there are tons of other people. A colleague of mine from the Heritage Foundation, I worked at the Heritage Foundation until 2014, he had a friend of a friend, I believe, who was chased by the Russian government for years and did not have the resources to fight back. And eventually they sort of fought it off. But how do you ensure through the internal and external mechanisms that Interpol uses red notices and what they call in English diffusions, probably translation of French diffusion, the sharing of information. How do you make sure that this is not abused for political purposes or, as Mr. Firestone described, when somebody is armed with a court decision? And I dealt in my advisory work with cases like that, where people go and obtain court decisions just to harass, to chase, to expropriate assets, whether it's in Russia or elsewhere, and then also that translates into the red notices work. So without further ado, we'll go to my right and further with the opening remarks, and then we will turn to the panelists to comment on each other's presentations, and then to the audience. So Melissa, you're first.
Great. Okay. This thing is on. Okay.
Yes.
Great. And so my name is Melissa Hooper. I work at Human Rights First. I worked in Russia for a number of years, not as many as Tom Firestone, but I also worked in Azerbaijan and Ukraine, Uzbekistan, Kazakhstan, and mostly on rule of law and human rights issues. And so in those places, I saw very clearly how these governments use criminal court cases, fabricated criminal court cases, fabricated fraud cases against opponents and critics and dissidents. But also then, as I came back to the United States, saw how those same strategies can be used to cross borders. I also think that it's the way we see Interpol being co-opted and changed by some of these authoritarian regimes is related to the way we've seen them co-opt other multilateral organizations, such as the OSCE, UN bodies such as the Human Rights Council, and also the Council of Europe and Third Committee of the UN. So when we look at the Red Notice issue from a human rights perspective, one of the main intersections that we're concerned about is the intersection with asylum rights. Essentially, once someone has been found to have been deemed to gain political asylum, this means that they will be treated with torture, cruel, inhuman treatment. There has been a finding that they should not be sent back to their country. And this is so inherent in international law that even countries that haven't signed on to protocols and conventions that require this are deemed to be required to not send people back. So even if you can't find that someone is an asylee, you still can't send them back to this kind of situation. However, in the United States right now, you do have situations where someone is requesting asylum and you have the Russian government using a red notice, and this person is in a situation where they may be sent back. So you have the US government in some ways doing the bidding of these regimes, and this is the problem. I've been asked to talk about a number of cases, so I'll try to do maybe a pre-reform case and maybe a post-reform case. Now, it's not like there was some big reform in 2015, but there were some attempts to limit some of the problems that were noticed in 2015. So before 2015, and a sample case is Pyotr Silayev from Russia. He was an environmental activist. He was active in the Himki forest movement that maybe some of you know about. And so he was protesting against destruction of the forest to build a highway. He was charged with hooliganism in 2010. He thought that this could be a problem because there were a number of cases brought against activists at that time. And so he left and went to Finland and applied for asylum there. He was granted that status of political refugee in 2011. In 2012, he traveled to Spain on vacation. As an aside, part of me thought that maybe the subtitle of this talk should be, if you're concerned, do not travel to Spain, because so many people, it seems, are getting red noticed in Spain. They arrest, I think, very quickly. So he is arrested in Spain. Police break into his hostel and arrest him, and they're, thinking this is this big terrorist. He brandishes his refugee card to no avail. The Finnish government gets involved to try to intersect on his behalf to no avail. And he is jailed in this well-known Soto del Real prison. He is also charged they begin to bring charges against him for terrorism, based on the red notice, which is based on the statement of the Russian government that he is a terrorist, a problematic individual. Luckily, there are organizations like Fair Trials International, and Bruno is here and can talk about this case, I'm sure, and larger problems. They have been involved in all of these cases, and in this case, after about 2 weeks, they were able to get a retraction of the notice, yet Silayev had to remain in Spain for 6 weeks until he could get the case dropped against him, and then it was another 18 months before he could get the red notice rescinded.
That was an extended vacation.
Yes, that's right, in Spain. So one of the problems in this case, pointing toward an issue that Tom Firestone mentioned earlier, is the information that was presented at the front end. The request, because Silayev was able to get a copy of it, consisted of 2 sentences. He joined a mob of 150 to 300 people, marched to the administration building, and using rocks, paint bombs, and smoke flares, did damage to the building. Note, there are no actions alleged on the part of Silayev. There's nothing said that he did damage. He joined a mob. And also going to the point of what kinds of criminal cases or criminal violations do we really want to be using Interpol notices for? Property damage is alleged with paint bombs and smoke flares. So, under this situation, this is someone who he once traveled to Spain and had this issue, but again, if he travels to another country, again could be red notice or the subject of a diffusion notice. So it was in 2015 that there were attempts to reform the Interpol system vis-a-vis asylum cases or asylum claims by saying that someone who is a refugee should not be subject to a notice if they can confirm their asylum seeker or refugee status, that the notice has been requested by the country from which they left to claim asylum, and the granting of refugee status is not based on political grounds vis-a-vis the requesting country. The third one, I feel like we could have an entire conversation about that one because it seems like it could be misused by receiving countries to swallow up the asylum exemption itself. Because it's confusing, and political opinion is one ground on which you can get asylum. So you are having a difference with your country based on political grounds. However, I think maybe what they're trying to do is, in a sense, restate Article 3 of Interpol's constitution, according to which the organization is not supposed to undertake interventions of a political, military, religious, or racial character. So basically, they're not supposed to get involved in political arguments between individuals and their governments. So if someone gets asylum, they should leave that alone. After 2015, I'm gonna try to stick to my time. So after 2015, we see other cases from Russia. I think the Kulichenkov case is interesting. He's a Navalny associate who is accused of stealing a poster worth €2. He fled to Lithuania. He gets asylum. He stopped in Cyprus on a diffusion notice, so a notice from state to state. It's not broadcasted necessarily to everyone. And he is stopped for 3 weeks. You see a Turkish case of Dogan Akhan, a writer and critic of Turkey, who fled Turkey in 1991, obtained asylum, obtained citizenship in Germany. And then in 2017, he goes on vacation in Spain, and Spain decides to arrest him based on a Turkish red notice. And again, this is someone who not only obtained asylum, but obtained citizenship after that. And then I'll finish up with a quick discussion of a case in the US. And I know that Dr. Shelley is one of the experts in this case, so we may hear more about this case today. And I know that we are all tracking these ongoing problems in the US, so I hope that we'll discuss this more. But Alexei Kharis is a businessman, who was from the Far East of Russia. He and a partner had a very successful business, but his partner, Igor Borbo, began to blow the whistle on corrupt practices and bribe-taking in the Ministry of Industry and Trade in the Far East, including by the minister, Manturov himself. This is in 2013. So what does the ministry do? It raids their company and seizes their assets. So this is under Manturov's order, the minister's order. A criminal case is brought against Alexei, accusing him of criminal conspiracy and laundering of $200 million. This is based on his refusal to cooperate with the FSB to testify falsely against his partner. So he flees and he comes to the US in 2015 with his wife and his children. They enter on tourist visas. His wife is then accepted into the marketing management program at UC Santa Cruz, so receives a student visa so they can stay. He receives a work permit, opens a bank account, leases property, starts a new business. He pays taxes. He's accepted into Stanford Graduate School of Business, and he wants to start a new life, so he applies for asylum in the US so he can obtain permanent legal status. Unfortunately, in 2015, the Russian government also successfully requested an Interpol red notice for Alexei and for Igor. So in 2016, Igor Borbo, his partner, is arrested based on the red notice in New Jersey. And in 2017, Alexei's visa is revoked. This is based on the red notice. He still thinks he will go to his asylum interview in August of that year because then he can have an exchange and can explain, and asylum is supposed to be the area where that happens. However, when he shows up for the interview, he's arrested based on the red notice. And the immigration judge at that time says, well, I know that you're not a threat to society. However, based on the red notice, I'm not granting bail. And I know that you're not a flight risk because you have a work permit, you have a business you've created, you've been paying taxes, your wife is here, you've been accepted into school, you're doing all of these things that counter being a flight risk. However, based on the red notice, I'm going to keep you in detention. So his request for asylum is denied based on the red notice. And he's denied bond hearings, and so has Igor been denied bond hearings based on the red notice. Igor has actually been denied bond hearings for 2 years, as far as I know. So you have a situation here where no evidence has been presented that would hold up in a court of law in the United States. There has just been a statement by the Russian government that someone was laundering money. That is a false statement, and that based on this, someone has lost their livelihood and has lost their opportunity to gain asylum in the United States, to gain the protection of the country where they were seeking protection. And this highlights an issue that we are seeing currently in US immigration courts that I think Ismail will talk more about this, so I'll just be very brief, that we are seeing an interest in the US government from ICE to try to identify those immigrants that are criminals, and a red notice is a handy way to do that. And so they are using these notices, which are, again, evidence-less notices put forward by authoritarian governments. And as a result, what we see is the US government doing the bidding of the Russian government, the Azerbaijani government, Turkish government, others. So maybe I have some suggestions for reforms. We can talk about that in the discussion. I think that it's very important for there to be exchange of information about asylum cases in particular. I will just wrap up by referencing a quote by Vladimir Gusinsky, another victim of red notices from Russia. He was a Russian media mogul, and in 2001, he was the subject of a misused Russian notice that was sent to the West, and he said in response, "The West must decide whether it will sit by and make friends with Mr. Putin or stand up for human rights and freedom of expression." And I think we're still grappling with that. Thanks.
Very good. Mr. Shekhtatinsky.
Thank you. Please feel free to stop me because I got a lot to say. It's
talk
very
yourself,
personal
10
topic.
minutes.
As an immigration lawyer, I often deal with individuals who applied for asylum and they've been reported to Interpol through red notice by the authoritarian regimes from where they fled. And the examples of cases that Melissa brought up, I often use those examples to show how easy it is to report an individual, to issue a red notice, and how there are no checks, there are no verification processes. For example, the individual who was granted asylum and became citizen of Germany, if Interpol was an investigative agency or had some kind of review process, how difficult was it to find out that this individual has already gotten asylum on the same basis that this country or Russia wants to arrest them? This means there is no review process. There is no, even if there is, it's just for the show. Unfortunately, and I'm very skeptical of the Interpol itself as an organization because of this. And there are lots of other cases where individuals who are in the news as political descendants or journalists, they are being issued red notices, and then how difficult it is. I mean, the world knows that this individual is fleeing from this country because of the political opinion, because of the persecution, and the Interpol allows this red notice to pass through. The way it plays in immigration courts in the US currently, the Interpol red notices are taken as truth, unfortunately. Under the previous administration, this was not the case. Under the Trump administration, I think it's part of the administration's general policy to intimidate asylum applicants. They're using red notices as the means to intimidate and to harass asylum applicants. So the way it plays out is an individual who comes into the US from the country of persecution and applies for asylum. And they're claiming that part of the asylum claim is that if I go back to my country, I will be arrested. And then Interpol red notice comes while their asylum case is pending. They do get arrested, but not there, here in the US. And as Melissa pointed out, the United States, unfortunately, is currently playing a role of a proxy for those authoritarian regimes. And most alarmingly, under the United Nations Convention of Status of Refugees, an asylum applicant's location, asylum application should be kept confidential, must be kept. The country that accepts the asylum application for review must promise the confidentiality. But most alarmingly, currently in the United States, the US government detains those asylum applicants and immediately reports to the country of their persecution that, hey, this dissident is here in the United States, and we detained him for you. While his asylum case is pending, how ridiculous it is, what have we become now? I was born in Azerbaijan and grew up in Azerbaijan during Soviet times, and naturally, most of my clients asylum applicants that I represent are from Kazakhstan, Russia, Azerbaijan, Uzbekistan, and coincidentally, those are the top Interpol red notice abusers in the world. And it's very well known. There are reports that these countries are top abusers. And in terms of what can be done to fix this, how Interpol can remain as a channel of reporting criminals and cooperation between the law enforcement in different countries, I think the reform should be that the Interpol red notices from countries known to the world as human rights abusers should be taken with a big grain of salt. It should be scrutinized, and obviously the benefit of the doubt should be given to the individual who was reported to Interpol. I slightly disagree with Mr. Firestone's suggestion that maybe to reform the Interpol, maybe we can ask for additional certifications from judges or law enforcement in those countries. And I'm not saying it's not going to be helpful. I'm saying I disagree. It will be actually hurtful. The reason because it would legitimize, the more certifications they provide, it legitimizes those countries' ambition to get this dissident back, or the underlying charge that they're accusing. And those charges most commonly are tax evasion and hooliganism. And I had a case with the Interpol, with an individual who was reported to Interpol for red notice from Azerbaijan in Atlanta Immigration Court. And Judge Wilson there at one point during the individual hearing asked me, why is the government of Azerbaijan using tax evasion as a charge, not murder, not something else? I said, because tax evasion is easy to accuse of, and it's very difficult to disprove. And it's the government who's accusing you of not paying. If you're saying, somebody committed murder, there has to be a victim, dead person, there has to be somebody reported, there has to be a police report. But tax evasion is just the government saying that he evaded taxes. So if you require certifications, the same government that is issuing this tax evasion charge, that's bringing up this charge, is going to certify. They can certify it a million times. I mean, I grew up and I work constantly in those countries. What we need to understand that the culture in those countries is very distant from the United States. The lying, the corruption is so pervasive that you can go to the chief judge of Supreme Court of Azerbaijan and Kazakhstan, pay him a stack of money, and he's going to write you whatever you want. I mean, it's so bad that there is not a single police officer that doesn't take bribes. So you can get police report on anything. You can get millions of certifications from Azerbaijan. It's just a matter of money. So when Ilham Aliyev is sitting there and pointing at someone, the certifications will be issued as many times as you want. So what I think should be done is it should be based on the objective reports. So those countries that are known as human rights violators, and that could be, for example, the Department of State issues every year the human rights report for each country. We know that the judiciary in those countries are horrible, corrupt. We know that they are persecuting dissidents. If an Interpol red notice comes from those countries, I'm not saying it should be ignored, it should be taken as a factor, but as an enforcement, Interpol notices in those countries should be more scrutinized, and obviously, those individuals should not be detained like in this country. And the interesting fact was Judge Wilson in Atlanta Immigration Court, after he asked tax evasion, and when I told him it's complicated, and then we went through the entire hearing, and during the entire hearing, the DHS counsel was trying to get into the facts of the case that my client had to disprove that he evaded taxes. And my whole point was that that's exactly what Azerbaijani government wants you to do, is to force this guy to explain in United States Immigration Court why or how he paid taxes versus not paid. But at the end of the hearing, Judge Wilson said, now I understand. He said that it was the most complicated case in his career that he heard. It lasted 2 days with experts and individuals. And then there is another case that I currently have from Kazakhstan. We went to the bond hearing here in Arlington, actually. He has Interpol red notice issued. It's a political opinion case, affirmative asylum applicant who filed asylum application before the red notice. He's now detained, and in immigration court, the DHS counsel tried to argue that Interpol is an investigative agency, which it's not. It's just a channel. It's channel for reporting something. And the judge bought it. And I don't know if the judges have specific instructions, but as you also brought example that all bonds are denied in those cases. But part of the problem with Interpol red notices is the popular culture, is that Interpol is described in all the movies and books as the sexy organization of individuals and investigators running around the world catching criminals. And I wouldn't be surprised if immigration judges are thinking of it that way until somebody educates them very well. And then we did that, fortunately, in Atlanta with in immigration court. But it will take a lot of time to educate each immigration judge about this. Thank you.
Very good. We're on time. Bruce.
Good job.
Yes. I'm a little bit different than everybody else up here in that I am not an advocate, I'm not an analyst of Interpol or whatever, but I'm somebody who has been affected by Interpol, and of course representing employees of Yukos who were abused by the Russian government with Interpol numerous times. So it's one thing I would say after listening to a number of the speakers, however, it seems to me that a big part of the problem, and when we're hearing some of this, and in terms of solutions, is the naivety of rule of law countries to accept verdicts, cases from countries that are obviously not rule of law countries. But the rule of law countries always feel that, well, it's our obligation to enforce the law. Well, in Interpol, you've got a very, very different situation, and you have non-rule of law countries like Russia, my experience, who come up with verdicts that are obviously political verdicts. They have nothing to do with law, and then they bring that into the rule of law countries, and they very naively say, well, we've got it. This is coming from a country that says this is their law, and we have to enforce it. And that's one of the big problems, and we've heard some of that already today. In my case, Yukos was expropriated. It's the largest expropriation in history. But they also had a case against Mikhail Khodorkovsky. They wanted to pursue him. So Interpol issued a lot of red notices against Yukos employees who had fled Russia or had been living outside Russia working for Yukos. And they were issued red notices basically to get them back to testify against Khodorkovsky and to come up with something. Almost across the board, that never happened, but the Russian government used the red notices in false criminal charges to try to get the UCOS employees back to testify against Khodorkovsky, not so much against the company, but against Khodorkovsky personally, and that it just didn't occur. Of course, Khodorkovsky got salted away under 2 different convictions that were totally false and contradictory, actually. So he ended up in prison for about 10 years and out now, and of course, one of Mr. Putin's primary opponents. Interestingly, before he was arrested, he was not a Putin opponent at all. He certainly had piqued Mr. Putin's interest about some of the things that the company was doing and some of his positions, but he was not a Putin opponent at all. Now he is. After having gone to prison for 10 years, Mr. Khodorkovsky is definitely a Putin opponent. Let me tell you how it's affected me, though. In 2006, we had some Dutch companies in UCOS, and we decided to fight a battle to preserve our international assets once we saw that Russia was going to expropriate the company. We put our international assets into a couple entities called stichtings in the Netherlands, and we've been very successful in protecting those assets through the stichtings. Russia has never been able to get a penny of UCOS's international assets, and all that money, hopefully, in a very short period of time, will be distributed to UCOS's former shareholders. We went through a 2-year exercise of identifying shareholders to be able to distribute to them. And some initial distributions have occurred already this year, to former shareholders, and we hope to do a lot more of that. But in conjunction with some of the cases in the Netherlands, in 2006, we won our first big victory against the Russian Federation or its fronts in Holland. The very same day, that afternoon, there was announced a criminal investigation against me and about 3 others. So it was clearly designed to intimidate us. That criminal investigation persists until today. I'm still under criminal investigation by the Russian Federation. They've changed one thing. They tied my case to Khodorkovsky's. It was an independent case, and now it's tied to his. So that'll go on forever because they're trying to make sure that Khodorkovsky never goes back to Russia. And as long as they have a criminal case against him, he won't go back to Russia. So my case is now tied, and they continue every 3 months to renew the criminal investigation against me. Well, what does that mean? Well, it means that as I travel internationally and what I do, I'm pretty much retired from all the UCOS activities. I've gone off the Dutch company boards in 2015, but I still am the main fact witness in cases, international arbitration cases against the Russian Federation. And so whenever I go outside the US to testify in these cases, it's very open and known that I'm going to be there. And so the only way that I go to some of these countries, Holland, not the UK, I don't worry about the UK, but certainly Holland. I'll be going to Switzerland next summer to testify. I always go under a laissez-passer, a letter from the Minister of Justice or the Minister of Foreign Affairs of the country that I'm going to protect me going into these situations, because at any point the Russians could turn this criminal investigation into a warrant. To the best of my knowledge, I've never had a red notice against me. I've never had a criminal warrant against me, only criminal investigation. But that doesn't mean that, boom, they can't do it if they wanted to seize me. And in fact, some of the discovery under various legal cases that we have, I found out that actually when I was selling a company by the name of Transpetrol, a Slovakian pipeline company, in 2009, we found an email that said, Missimor is in London selling this company to the Slovakian government. Can you nab him while he's here? I found that in discovery. And you know, that would have been an Interpol procedure just to try to intimidate me. So, you know, that's impacted how I viewed international travel. Certainly, I don't want to take any risks. My lawyers have advised me not to take any risks and so forth. So I don't take a lot of risks. Now, I've loosened up maybe a little bit, and if I can go in very quietly, international travel, fine. But when it's everybody knows I'm going to be there and testifying. I really take no chances, but you have to plan ahead on all these things. The UCOS employees who were impacted, most of what's happened in Interpol very recently, I think about 3 to 5 years ago, Interpol made a decision that anything that came to them with the name UCOS on it was a political prosecution. And so Interpol does have the procedure where if they believe that it is purely political, and we've been able to get that for UCOS employees, they will not issue the red notice. Something comes in Interpol, they just basically ignore it, which is what the UK does. They basically ignore requests from Russia. And of course, my experience has primarily been with Russia, but as Louise knows, also Armenia. We had a situation there with respect to asylum, where we had to pay attention to red notices and other things. But I think it's when you're dealing with countries where there is no rule of law. In the case of Russia, a lot of you have heard the term telephone justice. We shouldn't be recognizing verdicts from those types of countries because they are largely political. They have nothing to do with criminality. In the UCOS case, it was all about white-collar allegations of crime, which were false. So somehow we have to figure out how do we deal with, matter of speaking, rogue nations who use Interpol for their own political purposes, and it's purely political.
Thank you very much, Bruce. And I can vouch that everything Bruce said, I was part of that. I was the expert witness in some of the UCOS asylum cases, if you remember, with a good friend of TRAC, the late Sandy Saunders, who represented these people from Greenberg-Traurig. There are other countries beyond Russia. We talk a lot about Russia. By the way, was it mentioned that Bill Browder, the founder of Hermitage, got a criminal investigation for murder of Sergei Magnitsky 9 years after Magnitsky died? How absurd is that? Last but not least, Mr. Lin, please. What is your? There's nothing more important than experience in the trenches, and I understand you litigate some of these cases or you fight them. Tell us about your experience.
Right. Is this on? Okay. So, hi, my name is Bruno. I am a senior policy advisor at Fair Trials. Fair Trials is a global criminal justice watchdog. We have offices right here in DC, actually, but our headquarters are in London, and we've also got an EU office in Brussels. And what we do is to, as the name suggests, promote the right to a fair trial. And a really important part of our work as part of our cross-border justice campaign is to focus on Interpol, to highlight the misuse of the system and to find ways of fixing the problem. And we've been working on this issue since 2012. And in 2018, we published a new report highlighting some of the changes that have been taking place in the organization. So given that we've been working on this issue for quite a number of years, the last 2 weeks were very, very interesting. We've been working very hard to get this on the top of the agenda of people's minds. And all of a sudden, there's this thing about a Russian president, and everybody starts to talk about it. But the unfortunate thing about that was that because so many people were talking about the candidacy of Prokopchuk, there was also a lot of really bad information being flung about in the public. Haven't seen very much of that kind of bad information here because there's so much expertise in this room. But I thought I might, first of all, just wants to start off by kind of clearing what are those misconceptions and what the reality might be. The first was in relation to the role of the president and what that actually means. There were lots of comments about the Russian president being a way of Russia kind of being able to abuse Interpol more easily. That might have been an exaggeration, given that the role of the president is very much one of a figurehead and has very little to do, or practically nothing to do, with the day-to-day running of the organization. Having said that, we agreed that it would have been inappropriate for the president to come from a country that is very well known for systemically misusing the Red Notice system. The reason why we say this is because around 2 years ago in 2016's General Assembly, the Chinese delegate Meng Hongwei was appointed as the president. At that time, there was a lot of furor as well amongst the human rights community in particular about a Chinese delegate becoming a president. They were, as we saw in the past couple of weeks, very concerned that China would use its position to abuse its Red Notice system. And they were right to do so, given that China is also quite well known for misusing the system against political dissidents. We were encouraged to learn, however, a couple of years down the line, earlier this year, in fact, to find out about the deletion of the Red Notice of Dolkun Issa, who is a Uyghur rights activist who's been subject to Interpol Red Notice for, I think, over a decade. I think he's first found out about it, I think, maybe in the late 90s or even in the early 2000s. And that to us suggested that the role of the president and just how broken the system is might be exaggerated. So things aren't working as badly as some people say it is. There is some sort of a process, and if there is very clear political motivation with a Red Notice or a diffusion, there are ways in which that can be deleted. The second set of bad information relates to statistics. We heard statistics, for example, that singled out Russia as the worst abuser of Interpol Red Notice and diffusions. We also heard that 97% of Red Notices aren't being checked properly. And we also heard that the problem is getting worse and worse and worse. Now, the problem is that there isn't actually we don't actually have very much statistic from Interpol. So we don't actually know how many countries issue how many Red Notices. We don't know how many of those Red Notices and diffusions are found to be not compliant with Interpol's rules. So when people say that Russia is the largest abuser, when China is the worst abuser, or Turkey, or when they give these kinds of these countries as the worst abusers of the Interpol system, I don't know how well those claims are founded, because those statistics, as far as we're concerned, don't exist. The problem that was also high, the 97% of Red Notices not being checked, I believe that figure is from 2013, and there have been reforms implemented since, which kind of questions the reliability of that statistic now. And the other fact that was mentioned was that things are getting much worse. We would say that is totally not true, because in the past couple of years, Interpol have realized that they need to do a better job in terms of filtering out these Red Notices and making sure that countries are not able to abuse their systems. And a lot of these reforms have been mentioned already in the context of discussions already. One is in relation to the refugee policy that Melissa mentioned just now. The other is in relation to how Red Notices are checked before they are disseminated. And what essentially happened in around 2015 was Interpol changed how its circulation system operates. Whereas previously, requests for Red Notices could be uploaded onto Interpol's iLink system, which is the system that is responsible for disseminating this information, before they could be checked by the Interpol General Secretariat. That system changed so that these requests for Red Notices are not visible unless they have been checked by Interpol. So that's one major change. And also there was a setting up of the task force, the Notice and Diffusions task force, consisting of now around 30 people in the General Secretariat that's responsible for reviewing red notices and diffusions. And the third major change, which happened around 2016, is a major overhaul of the Commission for the Control of Interpol's files, which, as many of you might know, is the complaints mechanism that is kind of Interpol described as an independent body. And those reforms help to make sure that the procedures before the Commission for the Control of Interpol's files is closer in line with due process standards. There is a bit more transparency, and it's a much more efficient process. That's not to suggest that things are all rosy here. There is a reason why people are giving out all this really bad information about the organization, and part of that's to do with transparency. As I said, we really don't have any statistics that helps us to understand what's happening there. And to the extent that there are positive changes happening at the moment in Interpol, well, we don't know. We don't have statistics from Interpol itself to illustrate that there are changes. So we don't know how many requests for red notices and diffusions are being rejected by the General Secretariat for not being compliant with Interpol's rules. We don't know how many decisions, how many cases are reviewed by existing red notices are reviewed by the Notice and Diffusions Task Force. The refugee policy that Melissa's mentioned just now, that is not available on any of Interpol's official publications. So unless you know about the policy, you just don't know about the policy. So there is an underlying problem of a lack of transparency here. And then there's also the problem around kind of, how effective these reforms are. So for example, we heard just now that there was a lack of trust in how well Interpol is able to review requests for red notices. And to an extent, we agree that there is a serious problem here. If the review process was so effective, then we wouldn't hear of these cases. And one really clear case of this was the case of Muhyiddin Kabiri, who's a political activist from Tajikistan. He fled Tajikistan, and there were public reports that he was claiming asylum in a European country. That was reported in Radio Free Europe, for example. And if you just Googled his name, you would know that he's a political activist. And even after these reports had gone out, Interpol still managed to let Tajikistan issue a red notice against the individual, which makes us really question, if they are carrying out these reviews, what kind of information are they consulting, and how thorough are these reviews? And the other problem is a serious lack of staffing. So the Notice and Diffusions Task Force is a team of around 30. How many red notices are issued each year, new ones? Around 10,000. And we just had statistics recently from the German broadcaster ARD, who's making a documentary, that the number of new diffusions per year had shot up to around 50,000. They can't review all of this at current levels. What is worse, what is also quite concerning, I think, is that there is also a distinct lack of support, I think, being shown to the Commission for the Control of Interpol's files. We have a better understanding of how Interpol's systems are being abused. Therefore, more and more people are litigating on this issue, which means more workload for the CCF. And also, because of the new rules which require the CCF to, for example, produce written decisions, they have a lot of work to do. What happens at the most recent General Assembly, whilst this whole presidency hullabaloo thing is going on, the CCF budget has been cut, whereas the number of people in the CCF has increased by 1. So there are questions I think we need to address against this kind of backdrop of very bad information. There are real issues that we need to address, including issues around how we're going to support the CCF, how we're going to support the work of the task force in order to strengthen Interpol systems from abuse. Thank you.
Thank you very much. And this brings us to a question, and I would like to direct it to you, Bruno, and then start going back and encouraging the panelists commenting on each other's presentations. My first question is, as in many law enforcement situations, you have a balance. You have a public interest balance of preventing terrorists from running around, and especially after the events in Syria, for example, when the ISIS was defeated in the field, people spread around. People went to Europe, people went elsewhere into Asia, etc. So how you balance the legitimate concern, for example, about terrorism, or for that matter, organized crime, when you have transnational organized crime networks that are trafficking, as Louise's book so eloquently discusses, in weapons, in drugs, in human beings, in rare animals and animal products. How you balance the necessity in an increasingly globalized environment to intercept the really bad actors and prevent political opponents, religious activists, and other nonviolent types from being, and we heard many Russian, for example, business people, from being unduly persecuted and prosecuted by their host governments?
I think that question can be answered in probably volumes and volumes of books.
I'm not suggesting that.
The one approach I think that is misguided, I think, which hasn't been brought up here but has been brought up elsewhere, is for countries to be simply expelled from these organizations. There is a very, very real risk. There's a very, very serious problem here. But the solution to this problem is not to exclude countries from being part of organizations like Interpol, in our opinion. And that is because there are very real risks of dangerous organized crime, terrorism, and so on, which need a strong institution like Interpol to tackle. And they are strong and they are legitimate because they are global. If you start kicking countries out, that global standing of the organization is undermined. It undermines the organizations to perform its duties to keep the world a safer place. The other problem is that if you start kicking countries out, we end up obviously creating safe havens. We don't want countries like Russia or Turkey to become safe havens for very dangerous individuals, and vice versa. We don't want the streets of Berlin or Paris or New York to be filled with individuals who have fled those countries. That pose a risk to our societies. The answer to the problem is for countries to take a more cautious approach in terms of international cooperation. And I think on a micro scale, at least, that means that authorities, particularly, for example, the immigration authorities or immigration judges and law enforcement authorities should be better sensitized to the issues that we're dealing with here. And there's a distinct lack of that going on at the moment, as we've seen with the cases of arrests in Spain and the decisions that we've got in the US courts as well. It's particularly the problem is particularly serious, I think, in relation to asylum cases. That we heard some examples mentioned by Melissa in relation to this, but there are people who have been kept in detention for 3 or 4 years, primarily on the basis they are subject to a red notice. There was a case in Australia of a man called Syed Abdulatif, for whom that was the situation. I think the key is for countries to be better sensitized to what the issues are and take appropriate steps. And also not just that, for there to be better kind of communication between different authorities within the same country. So the law enforcement authorities or the countries that deal with international cooperation on policing matters are most likely to be aware of these difficulties, whereas the immigration authorities aren't. And that gap needs to be bridged.
It sounds like more public information, more education is what you're prescribing. Yeah. I would encourage members of the panel to comment on each other's presentations if you have something to say. If not, we'll go to the public.
Maybe just one thing,
Please.
which is going back to my point earlier. The rule of law countries, when you get a criminal case, or any kind of a case for that matter, in the UCOS case it was the bankruptcy and other things, coming into a rule of law country from a non-rule of law country, the very first thing that the US judge has done in our cases is to presume that he cannot make a judgment on Russian law and the case in Russia. And so they have to take that at face value. And only when you spend lots of time and lots of legal money to prove to them why that's not true, and we've been able to be successful in virtually all those cases. But it takes an awful lot of time and an awful lot of money to prove. And individuals who are being pursued don't have the financial resources to battle this in many cases. And so they cannot protect themselves. A corporation with resources, you can tend to protect yourself. But the other thing that happens, of course, is, and in the UCOS case, I can name names, but the Russians don't show up as Russians in the courts.
That's right.
They show up as, in our case, Clifford Chance, Cleary Gottlieb, Baker Botts, Debevoise Plimpton. That's who the Russian face is to the U.S. court system. It's not the Russian government itself. And these are some of their golfing buddies, and they're some of the premier attorneys in the U.S. or Britain. The guy that I'm opposing right now in an international arbitration is Baron Peter Goldsmith. Some of you may know that name. He's former Attorney General of the UK. He's representing Russia in an international arbitration. A former Attorney General of the UK. Come on. This is ridiculous. So when the Russians show up in these cases, whether it's asylum, whether it's anything, Interpol, they're not showing up as Russia. They're showing up as the premier law firms in the world. And that it makes it a very difficult situation to really sort out what's going on here, because our presumption in the West is, well, we're a rule of law country, and we don't kind of recognize that there are non-rule of law countries, and that's a very difficult situation.
Absolutely. Thank you. Just
Ariel?
just one example. Oleg Deripaska, everybody heard the name, a Russian oligarch that was allegedly involved in some kind of interaction with Mr. Manafort. A while ago, I was asked to provide an opinion to lift his visa ban, and I refused because I knew enough about Mr. Deripaska. However, to my chagrin, I found out that the former Senator Bob Dole and one of our former attorneys general of these United States represented Mr. Deripaska, partially successfully in the sense that he was granted a visa, less successfully because a condition of granting the visa was that he would talk to the FBI, and it was all downhill from there. But you're absolutely right. One of the things I do as an expert witness is to provide a long brief to the judge, to educate a judge, an American judge, as to the dealings of Russian courts and how abused and corrupt justice is in Russia. And there are differences in jurisdiction. In the Southern District of New York, believe it or not, they know all about it by now. There's so many cases there of different Russian companies fighting each other that the judges already know. You go to Kansas, it's Kansas. Sorry, I took your time.
No
Go
problem.
ahead.
No, I wanted to comment on what Bruno said about, and I agree that Interpol does have some improvements. One of the issues with transparency is also the criteria for review. They're saying political, we're not, the Constitution, Article 3 says that, Interpol's Constitution says that political, we're not going to, but what is the criteria to identify? I mean, the political, you don't have to be a politician to be a victim of political persecution. You can be a businessman, and you can be just an individual who disagreed with the ways of the government, or you could be a whistleblower who worked for a private organization that was giving kickbacks to to the government. So those are the individuals that most suffer, that those are the cases that don't get filtered because they're not political figures, they're not journalists, they're not known in the media. And so it's one of the issues with Interpol is the transparency of criteria for review of the cases. What is the criteria? In terms of the balancing, I think one of the things that also can be done is to categorize the types of crimes. The individuals who are being accused of tax evasion in their country, that's not a matter of international concern. That's not terrorist. I mean, if the country thinks that he evaded taxes, let them deal
Tell
with it.
this to the EU. The EU is on a tear to restrict tax havens and to go after alleged or real tax evaders.
Well, I'm talking about tax evasion in the country of persecution. I mean, it's not international. You know, if they had anything to do with offshore companies or so on, then maybe tax evasion, then it could be concerned. But I'm talking about tax evasion, somebody who's blamed of not paying their business taxes, and the United States, through Interpol, is detaining those individuals because some Borat in Kazakhstan pressed a button saying he didn't pay
That is
taxes.
stereotyping. I strongly object. Borat,
Well done.
shame on you. Your last words.
My
not
last words are
words.
actually a question, and so
Yes.
maybe that can be a question, to the panelists. I would be interested to hear Bruno's thoughts on this, but there may be other folks in the audience, so we can then open it up.
Yep.
In terms of thinking about reforms, I see a need for reform at the front end for increased initial review, and we talked about the problem of volume there. The information I have, and I admit this is, perhaps old information, is that the U.S. provides quite a lot of funding for Interpol, more than any other state, and so I wonder, does that translate at all to the U.S. weighing in on policies? And my second question on the back end, in terms of countries that do review the notices before they implement them, are there countries that do a good job, or is there a model of how review might be conducted at the back end, the enforcement end, by a country before they enforce the notice?
Well, I think one of the things that we're calling for at the moment is for countries to provide ring-fence funding for those parts of the organization that help with the review process. So the Notice and Diffusions Task Force, 30 people, that's not enough. What we want to do is to push for kind of entities like the US government, maybe EU institutions, for example, to provide ring-fence funding to help those institutions. And it's not as if this is like a very novel idea or anything like that. These countries get involved in various Interpol-related kind of specific projects in order to do things like tackle organized crime or human trafficking. There's no reason why a similar project can't exist for the review of Interpol alerts. What was the second thing that you said?
Review on the back end, enforcement end. Are there countries that do a good job?
I've not come across any countries that kind of give a model example. I mean, I think the reality is we are dealing with kind of law enforcement agencies, and I think we know all from experience that they don't like the whole transparency thing. So we don't really know kind of what kind of practices exist. You said that you had some good experience with the UK, and of course the UK is known for taking a more kind of discretionary approach in relation to acting upon red notices. But even in the UK, we've seen cases where it's not quite so good. So we've had one example of an individual who had his red notice, a Russian guy who had his red notice removed a couple of years ago. He was concerned about traveling to the UK in case there were traces of that red notice in the systems. And he spoke to us and we said, okay, we can't guarantee you anything, make sure that you've got proof that it was deleted and so on. I personally didn't think that anything was going to happen, and he was actually detained for a couple of days after he arrived at Gatwick Airport. So I don't actually know if there are any good examples.
And then, of course, we're not going to open this Pandora box, but to what extent intelligence community can use or abuse the red notice system. Because if they want to grab somebody, the first priority would be go through a legal channel, maybe go to a sister law enforcement agency, encourage them to issue a criminal case, to start a criminal case, issue a red notice, and then try to intercept that person, as opposed to taking extreme measures. But that's, as I said, it's a Pandora's box. We have huge brain power here, so who wants to comment or ask the first question? The microphone's available. The gentleman in the blue shirt over there, yes.
Gray shirt, but Adam Perlman, I'm one of the visiting fellows at the National Security Institute. With the gaps and difficulties in educating certain immigration judges and even district court judges, how have the appellate courts handled these matters? And how, if at all, will the Supreme Court's decision from last term in animal science products affect how these cases are handled moving forward? Animal science products is the Supreme Court saying that foreign governments' interpretations of their own laws can be persuasive in U.S. courts, but they are not binding.
Excellent question. We have at least one practicing attorney here, but in the interest of time, we have 15 minutes, so can you limit your answers to maybe a minute and a half, please?
Sure.
Thank you.
Very quick. So the Board of Immigration Appeals has a precedent case where they stated that asylum applicants, the underlying, whether they're accused of crime in their home country, should not be considered. It's not basically the asylum hearing is not a hearing on that country's laws, so it should be taken as a factor, but it should not be considered as the basis for denying asylum or the charges. So the appeals courts, the Board of Immigration Appeals at least has this precedent, which was affirmed by the circuit courts. But in terms of the recent cases, as I explained, the case in Atlanta where we won the asylum and the government appealed. So we won the asylum case from Azerbaijan against the tax evasion charges and red notice, and the government filed a brief, but the Board of Immigration Appeals appealed, and it's still pending. So we'll find out how Board of Immigration Appeals reacts there. The government's argument, the U.S. government's argument is that Interpol red notice means that this is a legitimate charge and legitimate crime, and that the U.S. should deny asylum and basically detain this person.
Very good. Anybody wants to add on that? Yeah, go
Just
ahead.
quickly, the case
Sure.
that I mentioned that was in the U.S., a Harris case, actually went into federal court, and the federal court granted habeas, saying there should be a rehearing of the asylum case. However, it's going back, it's actually being heard tomorrow in front of the same judge that denied asylum the last time, so I don't know how helpful that's going to be. And I would say, in response to your second question, in general, my experience has been that U.S. courts are very loath to honor foreign law and even international law. So I don't necessarily see this decision as providing any more support for looking to foreign law. But that's just kind of my anecdotal opinion.
Thank you. Gentleman here.
Well, thanks very much to the great panel. My name is Paul Massaro. I'm a policy advisor with the U.S. Helsinki Commission. Bruno, thanks so much for addressing this kind of idea that's floating around about, kicking out abusive countries and your objections to that. I wanted to bring up that in 1950, the United States pulled out of Interpol in objection to essentially Czechoslovakia pursuing political dissidents through the organization. And the United States stayed out of Interpol for 6 years until Article 3 was implemented. That's the origin of this, you cannot use it for political reasons. And I wonder whether this should be on the table again as a method to gain leverage for reform, or just because it's been being abused so badly. Thank you.
Well, it just as a thought, the member countries, especially the less democratic ones, would loathe to vote to kick out a North Korea or Myanmar and another really abusive country because, they may be next. And there are limits to how far you can go with that, I would think. But the idea of, you suggested U.S. pulling out or threatening.
unilaterally saying we've had enough, we're
Oh, that's extreme, I think, but what the panel thinks.
I mean, I think I've made my position clear already, but I think, if the US pulls out, kind of what other alternatives are there? And whereas for the other countries, let's think about this, kind of, we can't pretend that Interpol's the only problem here. The countries are increasingly creative, I think, in terms of abusing international cooperation mechanisms in order to hunt down the people they want. So for example, coming back to the Turkey example, I think I can't prove this or anything like that, but my sense is that Turkey's been slapped down quite a lot recently for trying to abuse the system on an industrial scale, I think. There were reports about Turkey trying to put out as many red notices as there were in the system already. And one of the things that they started to do, two things, was to use Interpol stolen and lost travel cards, travel documents and passport systems, so that dissidents living abroad are unable to travel across borders. That's something that might be happening. And the other thing that they started to do was they launched this alternative system called Terror Arananlar, which is kind of almost looks like a counterfeit version of Interpol's website. They have notices color-coded: red, orange, gray, green, blue. And instead of distinguishing the colors in terms of their function, the colors denote the bounty on individuals. And so they say these are the terrorists, and if you provide information to your local consulate or embassy about these individuals, you will get a reward depending on how serious they are. And the really disturbing thing about this notice system is, well, first of all, there's a lot of overlap, it seems, between the way in which they try to use the Interpol system and this particular list they've got. And the other thing is, well, the website is available in Turkish, English, Arabic, and German, which means that they are specifically targeting those exile communities who have found a safe place to live in democratic countries. And also there are a myriad of other kind of cooperation systems operating regionally, particularly in the CIS and Shanghai Cooperation regions as well, that countries really seem to abuse as well.
Yes? Tom?
Thanks. Since Mr. Ismail, it's easier, disagreed, made a good point about my recommendation, respectfully, about my suggestion that there be a system of domestic certification, a stronger domestic certification system. I agree, of course, in a lot of countries you can buy these things, and if you do have the Attorney General or the President or the Chief Judge of the Supreme Court certifying this, that would lend it a degree of legitimacy and make it harder to fight. However, at the same time, I think that they can do that anyway. If the government wants to lend legitimacy to an international arrest warrant, there's nothing stopping them right now from doing it in exactly the way that this system would require them to do. But I still think it would be valuable, despite the fact that these things could be bought, I still think it would be valuable for a couple reasons. One, not every judge, not every attorney general is going to be easily bought and corrupt. There are some who, when they're forced to put their name to something like this, would be deterred from doing it. And if it stops only 10 fatuous red notices a year, that's 10 people who are not being persecuted. So I still think it's worth doing for that. Secondly, if somebody was bought and they did sign off on something that later turned out to be fabricated, I think that would be an important data point that could be used by the international community, possibly as a basis for sanctioning somebody. An attorney general signed off knowingly on false charges against somebody so that they could be persecuted internationally. That would be something that I think would be useful to have on record for a variety of purposes, including possibly global Magnitsky Act sanctions and things like that. So I do think there'd be a value to it, despite the fact that it could be corrupted for the reasons you pointed out.
I agree with you, but I also think that there is already data that these, again, at least for United States, there is U.S. State Department country reports, which has the data. If you open it for Azerbaijan or Uzbekistan, it says that the judiciary is not independent to the extent that every judge, I mean, you're saying maybe there are 10 judges. Believe me, in Azerbaijan, there is no sense. They would not be a judge if they don't sign off on anything that they're asked to. They would not be there. There is no election of judges. Even if there was, there would be corrupt election. And so unfortunately, it's just so bad. It's just so bad. You're basically asking a murderer to certify that he didn't murder this person. I mean, it's as bad.
Okay, we have a question here, and then the lady here. Yeah, go ahead. Yeah. Just pass it.
Jonathan Reich from Grid Market Research. As an attorney who also works with individuals who have been targeted for Interpol red notices, it was heartening to hear some of Tom Firestone's suggestions for how we can stop fraudulent or corrupt red notices on the way in, but I'm curious to hear the panelists' thoughts on how we can improve the review system for this through the Commission on Control on Files. As many of you no doubt know, the 5 panelists currently sitting in 5-year terms on the Commission are comprised of mostly of states that Freedom House has found to be sorely lacking in rule of law, including Russia itself, and their representative there is a former deputy who served under the general prosecutor, Yuri Chaika, who's been targeted for U.S. sanctions here by a number of senators, as well as the Helsinki Commission, as well as representatives from the Ministry of Interior and Secret Services of Moldova and other such beacons of freedom, such as Angola. So with those as kind of the great protectors and verifiers of what is and isn't a legitimate red notice or diffusion, I'm curious what suggestions or policy reforms you might see that we could be advocating for to improve upon that review system to safeguard those people who have already been targeted for red notices or diffusions.
That description reminded me one of the composition of the UN Human Rights commissions that consisted of Iran, Nicaragua, Cuba, and Egypt, or something like that. So who wants to take this very important question? Bruno?
Well, I mean, I don't want to, I mean, it's very tempting, I think, first of all, to, I'm not saying this, you know, that's what's happening here, but it's tempting, I think, to make assumptions about people on the basis of their nationality.
It's not nationality, it's a regime.
It's well, whether, you know, obviously they're kind of appointed by the countries, so it raises questions about kind of what they do within these organizations. I share your concerns, for example, about the fact that I think, because each of these individuals are meant to have expertise in a particular field. The Russian member of the commission is meant to be the expert on international criminal law, and the head of the CCF is someone from Moldova, and that has raised a lot of questions around, you know, just how trustworthy this institution is. There have been built safeguards within the Commission for the Control of Interpol's files, which say that kind of, you know, the individual members are supposed to recuse themselves to the extent that complaints are made against any of their own countries. And also, we've been speaking to the Secretariat of the Commission for the Control of Interpol's files, who have said that essentially these individuals don't even get to look at the files in the first place if they do arrive. This is what they're saying, and you know, it's difficult because at the same time you need to kind of have a broad representation of countries on the commission. In terms of, you know, being able to fix the CCF, I think for us, our position is we don't yet know just how well these reforms are working at the CCF, and we're just kind of trying to work out, for the time being, what kind of decisions they're producing and how effectively the procedures are working. The good thing is that the CCF has become a lot more transparent than it used to be. So, for example, they are posting certain decisions on their website so people have a better understanding of how they make their decisions. There's also the repository on Article 3 that's recently been published, so we have a better understanding of how political motivation cases work. For the time being, it's not something that we are pushing. We do recognize that there might be some issues, but at the same time, it's early days in terms of the CCF reforms. They need to kind of work out what they're supposed to do before we're able to suggest any further changes, I think.
Very good. We have, yeah. Thank you, Louise. We have 5 minutes. So I'll start taking them in the batch of 2 now, and then probably 1 more round if we have time. Yeah, you were very patient here. Please, in front.
Thank you. Yeah, I'm just so curious
All right,
now.
can you introduce yourself?
Oh, Sally Stoker. I worked at TRAC for many years on many projects, and it's a great organization.
Yes, it is.
I love coming back. Anyway, I'm just really curious about the people who've been, the activists especially, who've been issued red notices. How many of them have been forced to return to their home country, and if so, what have been the consequences? And then
Excellent
just the
question.
second question briefly was, what has become of Bill Browder? What is his status now?
He's alive and kicking. Kicking hard. 1 more question, please. The gentleman in the gray sweater there.
Roddy Barquette, I'm with DEA. I worked at Interpol previously. There are some misinformation being given out. Red notice by itself, it's not a ground to arrest somebody. In order to arrest somebody in any country, you must have a provisional arrest, you must have the legal documents. Some of them, like the Russians and the Cubans, whatever, I agree with that. But for most part of the time, all these documents are legitimate. And Interpol will not just arrest you based on the red notice, as I stated earlier. Furthermore, you mentioned the funding. The U.S. federal law enforcement, it's all over the world, DEA, FBI, we are in pretty much all over. And when there's an issue, we reach out to the local governments, to the local law enforcement, and we share that information. For the United States to issue a red notice, you must have the provisional arrest, you must have the approval of the State Department, and we know the State Department monitor the human rights. So there are a lot of issues that are not being mentioned, and I thought I would just make the comment.
Very good. Thank you so much. So extradition or forced return of the red notice targets, any example statistics, outcomes?
From the US?
No, in general.
No, generally. Okay.
If you look at some of the annual reports of Interpol, some of those will give you some statistics about how many people, I think, ended up being surrendered or extradited because of a red notice. The good thing that I'm happy to report is, the cases that we've seen, that raise serious issues around the misuse of the red notice or diffusion system. Very few individuals actually were returned to the country that they fled. There were a few examples, I think, of certain individuals from Russia and China being sent back to their countries after they tried to make a claim for asylum in, I think, Thailand and certain other countries. But I can't share any more information about those cases because the fact that they were subject to any of these alerts it was never substantiated, and also we have no information about what happened to them afterwards. So I'm afraid I can't help you with that. The gentleman's points about the red notice is bang on point. The really frustrating thing about this red notice is that it doesn't actually have any legal value per se. It's up to the countries themselves when they receive a red notice to decide how they're going to act on it. And sadly, because of a lack of awareness, that's how kind of cases of injustice are caused. And it's not simply the fact that individuals are subject to extradition. It's the process of that happening. Individuals are going to be detained for lengthy periods before the extradition proceedings can take place. And your comments around the US having safeguards is very encouraging, obviously, but obviously we're dealing with 194 countries and what they're doing, not just what the US is doing.
Exactly. Okay, we are out of time. I will, not just for the gentleman to finish, so
Okay.
please. Yeah, go ahead.
Yeah, just wanted to comment. In the immigration field, the way it works is that the Immigration and Customs Enforcement, the Department of Homeland Security, reacts to red notice. So it does not go through the checks of the reviews of the State Department. They just see the red notice. The Immigration and Customs Enforcement has the power to detain any immigrant who is in the process of waiting for decision. So when they see the red notice, they overreact to it now under this current administration, and they don't need any arrest warrant. They simply have the immigration laws saying that this individual is here. Obviously, they're without status. They're pending asylum application. So they immediately go detain, and they sit in immigration detention.
Actually, ICE have a seat Interpol and they review each and every red notice.
ICE reviews it.
ICE does.
Yes, and they're the ones who arrest those individuals here in the U.S.
Interpol, the United States National Central Bureau, before a red notice is issued, it has to be approved by every federal law enforcement agency seated in that office, as well as the General Secretary.
Do you want to share it in public, what you're saying now? Yeah, Louise? And that will be the wrapping up comment.
Well, I just wanted to get these. I'm going to talk this afternoon, but we have serious problems from the U.S. side of lack of competence in reviewing some of these documents. Because one of the things I did a lot before I held this conference was talk to people who were in the formerly in the legal department at Interpol, who explained how submissions now are increasingly being done to deter, let's say, oversight, so that they're becoming much more clever in how they are submitting these documents so that they're not raising the red flags that they should be. And that's an issue that we need to talk about, and there's also an issue that we need to talk about of how we're not having enough oversight within the United States of these political issues that should be raising red flags. That it's not some major dissident figure like Navalny, it does not show up. And yet there is targeting of dissidents all through these countries that we're talking about that are not being reported because the media doesn't report things in the regions.
And with that, ladies and gentlemen, what's that?
I will ask my question after that.
Okay.
Yeah, I think it's not will be quickly. I can wait. My name is Evgeny Ryzhov. I am a Russian attorney. I'm a human rights activist who was subjected by a red notice here in the United States. I was spent 22 days in jail here. But here, my question is, I'm head of one public motion, stop arrest. I behind his 55 peoples who live in different countries, and they are subjected by Russian government because they have a good business in Russia and different issues. But now they send their request to cancel their records from wanted list. It's happened 2 years ago, 3 years ago, but the Russian party didn't submit to Interpol confirmed documents about the issues, and they're still waiting their resolve. We don't know what we need to do right now because it's awful too.
This is a very important issue, and I hope our next panels can address that. Thank you very much. Thank you for the panelists. Let's give them a round of applause.